so jy moet hom aanhou, neem ek aan.
Ja, seker. Ja, ek wil seker sê. Jy sê dit is net 'n vlieg sit. Wat sê jy dan? Ek gaan check as ek dit afhaal of jy my kan hoor. Kan jy my nou hoor?
Jan, baie tof.
Okay. Ja, moet ek die headphones op?
Ek dink jy sal moet ophou.
Okay, nee, dis reg. Dit is moeilik want hoe na die regte, seker deur die skerm. Ja, okay. Wel, laat ons kyk, dis baanbrekerswerk.
Ek is jammer vir my moeilikheid, dit is nie my skuld nie, hoop ek. Niemand reken dit vir my toe nie.
Ja, ek dink jy's gelukkig dat jy daar sit.
Kan 'n mens kwarantyne op 'n plaas?
Quarantaine?
Op 'n plaas?
Nee, jy kan as jy wil, maar ek tog. Sit. Zolang het nie voor die regters is. Yeah.
This is on their way. Can you hear me? Okay.
Okay, they've gone online.
What?
Use his mask in there.
Send it now, Jerome. I just sent it. Who's the deciding judge? Because the others they do. Right. Rockview investment number 71, CC versus Nottingham.
May it please, Lords, I appear for the appellant with my learned friend, Mr. Oppus, on the instructions of Fisher, Kwambi, and Pfeiffer.
As the court pleases, my lords, I appear on behalf of the respondent together with my learned friend, Mr. Dalton, on instruction of Pierre Erasmus attorneys.
Thank you very much. Logistics. We propose that counsel who address us only will have his video on. Mr. Kruger on the other side will have his video on. The junior must be only on audio, but leave video off. That helps with, and same applies to Mr. Mares Jr. and those instructing. Only audio, no video. Is that in order?
We shall do so.
Mr. Mares, did you get it? You will have audio and video on. And your counterpart on the other side leading will do the same. But your juniors and those instructing you will be only on audio, no video.
I follow that.
Thank you.
Lords, I have instructing counsel next to me only because I have a serious handicap when it comes to technology.
That's not.
And if there's any problem, then you could move to the back.
Sorry, Mr. Maria, I'm not sure what my colleagues' position are, but I mean, for the sake of your counterpart in Pretoria, if you stand up on the video, we only see your waistcoat. It's probably better if you sit and just maybe take the podium away in front of you, if it's possible, and just read from a seating position, please.
I guess we're breaking new ground again.
I just want to make sure that everything is in order in South Africa. Is that Mr. Kruger? Is it in order with you?
My lords, I do not mind. If only I need to hear him, that is fine. I do not need to see him. But the directive of the court will prevail. I don't mind either way.
Thank you very much. Yes, Mr. Matamari.
As a court, please. Lords, firstly, there is an application for condonation that arises from the security that was not timeously ended. It is an application that is not opposed. It is our submission that it involves a very short time period and there is good explanation for it. And in any event, if one were to count the days from the day when the reasons were given by the court a quo, then our submission is that in any event it would have been timeously lost. And there's no clarity prejudice at any time. It simply arose from initially the uncertainty on the part of those instructed as to whether security should be given in a matter of this nature. And then it is also explained with reference to the short delay in between the date of order and the date of.
Yes, thank you, Mr. Matamara. Mr. Kruger, anything you wish to say about the condonation?
No, we do not oppose the application for condonation, my lord.
Thank you very much, Ma'am. Condonation is granted.
As court pleases. Lords, the starting point, if one were to just look at the case from a high level by way of starters, is to recognize that we are not concerned at this stage with the merits in the sense that it is going to become an issue if one were to actually run the trial. In other words, it is similar in a sense to an application for setting aside a judgment granted by default, except that you don't need to show condonation for a delay or the lack of knowledge. What is required is to demonstrate that you may have a reasonable and bona fide defense. And that is an important point of departure that we submit may not have been as acutely recognized until now, both before the court a quo and in the form of the affidavits that have been filed on behalf of the respondent. In other words, if the court is satisfied that there is a reasonable prospect of a defense which arises on the papers raised bona fide may succeed during the trial, a liquidation order should not have been granted. So the onus is a very light one. And those authorities to which we've referred the court, they all basically underline the nature of the onus. We have taken the trouble of preparing what I'll call the authorities bundles. And by way of reference, I can just make a reference to the page numbers so as just the court when you might want to consider the question. In the first authorities bundle, we find references that begin at page 15 from Henochsburg. And what Henochsburg is saying is that in such a case, the respondent bears no onus to establish that the company is in fact not indebted to the applicant, but only that such indebtedness is disputed on reasonable grounds. Accordingly, the court should dismiss the application if on the evidence contained in the affidavit, the company charges the proving the dispute is bona fide and on reasonable grounds. And those sentiments are repeated and echoed also by way of reference in the same book at page 25. And that arises from the judgment of Payslip Investments, page 25. The second paragraph following the introductory paragraph by His Lordship Mr. Justice Brunt, where he said, with reference to dispute regarding the respondent's indebtedness, the test is whether it appeared on the papers that the applicant's claim is disputed by the respondent on reasonable and bona fide grounds. It is also referred to page 29 in the same bundle, and Lords would see specifically touched upon by, in the Badenhorst matter by His Lordship Mr. Justice Hemstra, and again at page 36, remarks to largely the same effect in the HGU matter in paragraph 14. And then finally on this issue, in the same bundle at page 50, largely remarks to the same effect. The question is whether the debt is disputed on bona fide and reasonable grounds. So our submission is that it's right that one must see an application of this nature in context. One must at the outset, it is not as if we are now going to be involved in the trial and resolve factual disputes that typically would arise in the trial, as in the case of an application to set aside a default judgment. All that is required in 5 days appearance, to use that phrase, the appearance of a defense that might arise on the merits. And that, with respect, sets the scene for this application, because there is no dispute on the factual allegations that underlie those that are made on the merits. And I'll deal with the merits separately, but naturally all that the respondent could do was to rely, as it did, on the judgment debt and maintain that that was sufficient, and therefore that the judgment debt is enough to have given rise to a suretyship liability. In a sense, that in our submission would represent the heart of the case, read with the ancillary issues that somehow associated with it. But the point I want to make by way of an overview is that when it comes to the underlying circumstances that related to the conclusion of the agreement, the original sale agreement, and the deed of surety, one must view the matter on the basis, firstly, that the onus to be discharged by the appellant is a very light one, and combine that with the fact that there are really no gainsaying evidence on the factual allegation that underlie the defenses that have been raised. That is evident if one were to compare from the record, volume 2, at page 189 to 193, did I say volume 2, Lord? In volume 2, 189 to 193, where the allegations are made to the effect that it was known at the time of the conclusion of the sale agreement that granite would be mined, that they would supply the granite in accordance with the existing practice between the parties, that there were enough of those stored at Stone Africa for a 12-month period of delivery and the rest could be mined, and the suretyship was executed in the comfort of the knowledge that there was sufficient granite available to enable VXK to comply. The deponent went further over the page 190 to make the point that therefore the orders had to be placed by Nottingham. It had to engage shippers to pay for the shipment. Then it had to choose the different qualities, colors, and finishes that it required. And the deponent went on to explain on page 191, my lords will see it, paragraph 47, that therefore the suretyship was also executed on the basis of that knowledge that there would be compliance with obligations. I should interrupt myself in that sense to just indicate to the court that when one look at the timeline, the suretyship actually preceded the sale agreement. We don't know if there were drafts that were exchanged, but it is something that I picked up during my preparation. There's an error in our heads of argument on the chronology. The date 2020 appears when it should have been 2010. But just to assist the court in that regard, the suretyship was executed on the 10th of December 2010, and the sale agreement was concluded on the 14th of February the following year. But those are issues that would not normally and naturally be canvassed during a trial. The deponent went further to deal with the fact that what then happened is that it happened fairly quickly. In August 11, already Mulder flew to North Carolina to establish what was going on, and then he realized that there was no real prospect of any further deliveries. Nottingham was already in the process of winding up its affairs.
Mr. Marais, sorry, I just want to ask you in the context of the suretyship. There's two questions, but the first one, because you and Mr. Creer seems to be on different places in this regard. One is there were three elements to your client's indebtedness. Well, there's three elements to the contract, let's put it this way. There was a cash upfront payment, which was made. Then there was a second cash payment that had to be made, which wasn't made, which now runs to 432,000 US. And then there's the component of the deliveries, in fact, in prestanda. But you don't raise any defense against the second cash payment, the 432.
No, because our submission is that the only obligation that the surety undertook as a surety is the obligation to have granite delivered.
So you...
No, indeed not. Can I deal with that because it touches on the, I think what my lord is saying, and I'm not, argument assumes that if the surety is liable on a proper construction of the deed of suretyship for the obligation to make payment, then two things flow from that. The first is that the defense of prescription would naturally fall away, because then the judgment debt would have reinforced the original indebtedness. And the second would be that a defense that falls outside of that judgment would naturally no longer apply, because that is, if the suretyship is wide enough to cover the debt, the judgment debt, then there's no defense about that, because the authorities make a long line of cases that disagreed since the judgment of His Lordship Mr. Justice Baker, that judgment debt constitutes a separate liability and could therefore constitute a liability that would not prescribe before 30 years, and that the surety is bound by that. So I guess what I'm perhaps not defining as clearly as I could, is to make the submission that, leaving aside section 350 notice and locus standi, which we're not abandoning, but to try and focus on what represents the crux of the case, the issue lies in a contextual interpretation of the deed of suretyship, and associated with that, and perhaps not entirely on all fours with the interpretational issue, is the question of whether, by not ordering granite, the suretyship was released because that frustrated, was an act to the prejudice of the surety. But it means that we do need to accept that. We need to look at the deed of suretyship. For that, may I begin with the deed of sale, because these things seem to be talking to each other. If you look at those pages, you'll see, Lords, appear from page 47 of volume 1. Now, if we go to the deed of sale at page 47, we know what has happened is that Nottingham sold its shares to the appellant, or to at least to VXK, and that the deed of sale was structured in an odd way because it provided for different means of payment. At page 47, the preamble appears where the parties are identified. We know that it's Nottingham selling to VXK. At page 54, you'll find the reference to the purchase price, that being in clause 1.2.25, purchase consideration of $4.5 million US. Page 54, my lord. In 1.2.25. So the general purchase price is 4.5 million. The purchaser is defined in the following subparagraph. Over the page, you'll see the seller is defined as Nottingham. The Marx is defined as the interest in the shares. And then if you go further, you'll see that there are references, I think it was at page 57, to the surety. Rockview, that's in clause 2.1.1. Rockview binds itself as surety and co-principal debtor on behalf of the purchaser in favor of the seller, limited to the amount of 2.5 million. Which, if one were to read just up to this point, would allow anyone to say, well, your liability is, on the face of just that bit that we've read, a wide, all-embracing liability, but limited in amount to 2.5 million. But we then go over the page to page 58, and the method of payment is then very specifically broken down in clause 4.1. There is a first installment in cash of 1.5 million US, and a second installment over the page, Lords, will see, for a further 500,000 US. And then the important clause, clause 4.3, which says the balance of the purchase price of 2.5 million shall be payable by the purchaser by virtue of the purchaser procuring delivery of granite material to the seller or its nominee. Now, this is the first and the only further explanation on the 2.5 million that we've just seen. And so automatically the two already begin to show a connection when you look at it in that context. You say to yourself, okay, the price is 4.5 million. And the only 2.5 million to which there is reference is the 2.5 million that the surety would stand surety for. And that 2.5 million is then described in clause 4.3 as payable in kind. And if one went further, since I am in that agreement, because it is also relevant to the remainder of our argument, Lords, we see that the common law principle is endorsed on page 68 in clause 15. We've gone to a fair amount of trouble to refer you to all the cases that started with the doctrine of fictional fulfillment, but I guess it's trite now, and for that reason I don't want to belabor the point by taking you to all those cases, but I think it can be said that whatever the origins may be and whatever its association may be with the doctrine of fictional fulfillment, it is now trite that at the very least a party's obligations are suspended when for as long as the other party is in breach of his obligations in terms of the agreement. There are even authorities that suggest where you intentionally do not comply with your obligations, then it is taken that the other part, and that has frustrated the ability of the other party to comply with his, then that is taken to have released the innocent party, despite the fact that he had not complied with his obligations, because his non-compliance arises from your intentional act, intentional not in the sense of dolus malus, but the normal intentional act. And that's what all the authorities demonstrate. Now, here we have that very same principle endorsed in the contract in clause 15. It says, notwithstanding anything to the contrary, herein contained, neither party shall be obliged to perform any obligation or pay any amount in terms of this agreement at any time whilst the other party is in breach of the agreement. And Lords, it is a classical factual issue that must be determined at trial. Was there a breach? And if that is so, how does it affect the surety? Via the liability of VXK or by reason of the surety being released because of a frustration of the obligation that was undertaken also to the principal debtor. And so there is a narrow division that one must bear in mind when it comes to the interpretation of the suretyship. If my lords were to find that the suretyship is wide enough to cover the judgment debt, then there is still the remaining issue of whether the failure to order any granite or place any orders discharged the surety because it frustrated the surety's own interests by reason of what clearly would amount to a breach of contract. So there are two narrow but separate, albeit perhaps associated routes by which the appellant could get around the order that was granted, both of which naturally fall to be determined by way of evidence. Now, my Lord, the cases, and we've referred to a fair number of them, there are others. I've discovered cases that are of the same effect, and we've prepared a further bundle or two during the course of that. We were duty bound when we realized that there was a judgment by Ladyship Madam Justice Rakol in Swartboy to disclose that judgment, because what she did is she effectively found that a surety ship was, that there was no defense of prescription available to the surety where a judgment debt had been granted in favor of the creditor. But, and can I hand up those to my lords? My learned friends in Pretoria have been given copies. If I have leave, they might be of assistance. But all of those judgments, including that recent judgment by the local court, High Court here, approached the matter from the terms of the suretyship. And although in the case of her ladyship's judgment, it wasn't entirely clear what the deed of suretyship stated there, she quoted it. Lords will see in the bundle that has items 5, 6, and 7 on it. It's the judgment in beginning at page 29, the quote, the only indication of what the suretyship terms reflected there is at page 31 of that bundle, where she said, she quoted from the, apparently summed up what was in the deed of suretyship. She bound herself in her personal capacity as surety in solidum and co-principal debtor with Zappies for payment on demand. It's right at the top, Lords, we'll see, for payment on demand of all monies which the principal debtor may from time to time owe or be indebted to. Now, that and the other cases that dealt with it, to a large extent indicate that the suretyship was wide enough to also cover a judgment debt. And that would be the starting point in our submission when we consider the suretyship, is to see how wide it is. Because, allow me, Lords, just to go back to general principles. A suretyship is a contract like any other. It has to be interpreted like any other contract. There are authorities that suggest that because it gives rise to liability of an accessory nature, it should be restrictively interpreted. But let's assume like any other contract, it should be determined in the context with the relevant circumstances and the purpose taken into account, as was determined by this court in the Total Namibia case, and has now become an accepted method of interpretation in both South Africa, and in fact, for that matter, in England. Although I understand that more lately in South Africa, the Supreme Court of Appeal has again re-emphasized the grammar as the obvious starting point and the language. And even in England, very recently, I see that the Court of Appeal there has adopted the same, maybe one could refer to it as a rowback stance. But it means that as a general approach, one must consider the fact that, like any other contract, a suretyship is to be interpreted in the normal, ordinary sense. And that would mean that you must consider suretyships could be limited in terms of amount. We all know that a suretyship might say you guarantee the liability of the principal debtor, but up to a limit of 1 million. A suretyship may be limited in terms of duration. There's nothing wrong with the suretyship that provides that for the first year following the contract concluded with the principal debtor, the suretyship would be effective and then it would become unenforceable. Clearly, that would be entirely acceptable. So now we have a suretyship that is covered in terms of time period, in terms of amount. You could also have a suretyship that is limited in terms of the embracement or the debt or the nature of the debt. And the suretyship could notionally therefore be executed on the basis that although the principal debtor might owe the bank various amounts of money, the surety could say, I would stand suretyship for account 1, 2, 3. And if therefore subsequently there is a debt that arises from the other accounts and 1, 2, 3 has been paid, the surety would be entitled to say, on a proper interpretation, I'm not liable for that account. And so if that is the starting point, then the answer must lie in interpreting this suretyship. And for that purpose, can I invite the court to go to page 113? I'm answering His Lordship Mr. Justice Frank's question because it does go to the crux. If that suretyship had stated, perhaps I should just say this by way of introduction, that Rockview bound itself as surety and co-principal debtor for any amounts that might be owed by VXK arising from whatsoever cause or from any cause whatsoever, then that would clearly cover a judgment that is granted and is relied upon in this case by the respondent. And that is what most of those cases that dealt with the topic had to deal with, was a wide, what I will call a wide suretyship. If we look at this one, the introductory words next to marginal 10 give some indication of support for the notion that this is a wide or all-embracing, because it says, hereby binds ourselves as surety and co-principal debtor. But we know from the authorities that when you bind yourself as a co-principal debtor, effectively what you actually are saying is that you cannot rely upon those unique defenses available to a surety, excussion and division and so forth. And it allows the principal the creditor to sue you immediately if the creditor had wanted to do so. But then, and then we see about the fourth line after the marginal 10, for the due and proper fulfillment of all the obligations of, and for the punctual payment of all sums of money which are or may become due by VXK. Had I stopped there, we would have been on similar grounds as the surety was in the Swartboy matter, because it would indicate a broad liability. But we know, Lords, we must look at these things in context. You must give meaning to all the phrases in a contract and then contextually decide, what are we dealing with? What did the parties intend? And the answer to that arises when you read further next to marginal 20. Because then we see there is a very specific reference to the sale agreement. That's the first indicator of a limitation. It says in terms of, or in connection with, or arising out of the provisions of, and not just the sales agreement, we see clause 4.3 of the sale of shares agreement. And Lords will recall, going back to the sales agreement, that clause 4.3 is this very clause that is concerned with the pay in kind. So if we read up to this point, the surety is effectively saying, I would be liable to guarantee payment in kind as it arises from clause 4.3. It may or may not be that that payment in kind was found by the arbitrator to justifiably have been replaced with a monetary payment, but that doesn't affect the surety, and the surety wasn't party to those proceedings, so there's no question of res judicata. The surety, with respect, Lords, could still rely not only upon the restriction contained with reference 4.3, but also the failure of the creditor to have made it possible for payment to have been made. It is, with respect, a classic case of payment being frustrated in circumstances where the counter obligation is suspended at the very best for Nottingham, and if not that, resulted in the frustration of the surety's rights in circumstances which would automatically have released the surety. This typically in our submission represents the kind of issue that can only be dealt with at trial. But we can read further, because my Lords will see that next, I'm back on page 113. It is recorded, the last part of that preamble after there was reference to clause 4.3, it is recorded that this surety is limited to the obligations of VXK towards Nottingham Inc. by virtue of clause 4.3 of the agreement only. I guess the only could have been by virtue of only clause 4.3, but the meaning is clear. So we have a classic example of a suretyship that is no longer a wide, all-embracing suretyship that so often featured in these cases that dealt with the judgment debt. And the judgment that the court AQO relied upon from His Lordship, Mr. Justice Farlam, in the shipping matter indicated that one of two things could happen. You could have a reinforcement of the original debt or an entirely separate new cause of action with the judgment. In this case, it is recorded that the surety is limited to the obligations only by virtue of only 4.3. And even further on, we see the same trend, Lords. We know that at common law, if there is a novation of a debt that the surety had undertaken to guarantee, the surety is no longer bound because it constituted a new debt, unless, of course, we are again talking about this completely wide type of suretyship that embraces everything. And it's possibly with that in mind that clause 2 on that page says, on the second line, and if any action by results in a novation of any debt or liability, then between VXK and Nottingham, and a new transaction is concluded in the place thereof, then we undertake to be bound also in respect of the novated debt. I mention it because it might be suggested that the judgment is a novated debt, but it isn't. One sees fairly clearly, if you read it all together, that the meaning can only be this. The surety says, okay, I'm not going to bother about payment, but that there's a lot of granite available, 12 months at least, and the rest can be mine. So I will stand in for that obligation. But perhaps they persuaded him to also stand in for a novation that replaces that in the context of an agreement. And that is the only slight extension that then arises. Now, Lords, that must mean that we are dealing here with a clearly restricted deed of suretyship that cannot be seen in the light of Bulsara and all those cases, including the case by His Ladyship, Madam Justice Rakal, and Hill and Ely, the other cases to which there was reference, and we've included them into the last bundle of additional authorities. So the case we are talking about is, with respect, clearly distinguishable from those cases, clearly distinguishable in particular from the Swartboy case. Then on page 114, in clause 11, Lords will see a very clear endorsement of the surety's rights to raise a defense that is available by the principal debtor. Should we at any time in defending any action based on the suretyship and allege that there is no reason or cause for VXK's obligations to Nottingham, the onus of proving such a defense will rest on us. And so all of these clauses fall into harmony. What the surety is saying is, I undertake a limited liability in respect of the obligation of VXK to give you granite. And if VXK has a defense, i.e., your failure to order granite and thereby frustrating its ability to deliver and comply, then that defense is also available to us, but we will then bear the onus of discharging that defense. And really, once that is accepted, my lords, our submission is that self-evidently we are talking about one of those restricted kinds of suretyships which have to be interpreted in that context. And then one automatically cannot rely on the judgment debt because it's not covered by the judgment debt. And we know that that is the only reliance for a claim that the respondent relies upon. The respondent made that clear on more than one occasion in our learned heads of argument. It is self-evident that the point is being made, I've got a judgment, and that's enough. And you'll see it from the papers if you needed the reference, Lords, in volume 2 at page 220 and volume 2 at page 224. And that is one of those requirements which rest squarely upon the creditor applying for the liquidation. He has to have made out a case that a debt is owed. The appellant says there's a bona fide defense about whether it's owed. It's evidence dependent. You haven't even bothered to challenge the allegations that we have made. And I've given Lords those pages where on the merits these allegations are made. The response is basically a bare denial. And Lords will see that from volume 2, page 189 to 193, and volume 2 from pages 2 to 223. And we know, it's trite by now, that since Plasko and Evans, that simply denying a fact doesn't give rise to a factual dispute. There's that nice phrase by His Lordship, Mr. Justice Roux, in the WL, where he said, pouring scorn over your opponent's version doesn't give rise to a factual dispute. The same applies to a simple denial. And one can't blame the respondent for the simple denial, because we know the respondent is actually the receiver or liquidator. How would he know about all of this background? He clearly can't know about it. He came into the picture when it became clear that Nottingview was against the ropes. And so those allegations are allegations that are actually unchallenged on the papers, and in themselves would justify that the application for liquidation be dismissed, or that it should have been dismissed. Perhaps the obvious example that I could use, so therefore on the factual basis, Lords, there is no debate about it. They never ordered the granite. Mulder explained that when he flew to North Carolina, it was very clear that Nottingham was against the ropes. It was busy winding down its affairs. It couldn't place any orders. But now, says the respondent, we must now pay the amount. And says the appellant, but you didn't place an order when I knew that that was the whole basis. All the cross references make it clear that you were going to place orders. Clearly, you frustrated my ability as a surety. The protection that I gave was on a certain basis. You've gone and frustrated my rights by doing that, apart from the fact that you've not honored your obligations vis-a-vis VXK. And it makes good sense. Imagine if, hypothetically, Lord Justice Frank had a villa or two villas in Greece, and he was going to sell one villa, both of which operated profitably as businesses, and I showed interest to purchase, and he was saying to me, we would continue to use your villa for bookings and thereby generate an income with which to pay off. There's nothing strange about such an arrangement. It is dependent upon further bookings coming the way of the second villa. And in those circumstances, if something were to happen, a surety at least could, but that is the basis upon which I executed the suretyship. And this is what we are dealing with here. If it was the opposite, the wide deal of suretyship that we were concerned about, all of those portions that I've read to Lords would be meaningless. All that they could have said is, you'll be liable jointly and severally principal as co-principal debtor for all debts owed by VXK, howsoever arising. End of story. And that is the case that, or the types of cases that, or the facts that underlined those other cases.
And that would be, and it'd be immaterial that Rockview is insolvent.
Put yourself off mute.
My little friend is on mute. I cannot hear him. I'm sorry. Mr. Murray is on mute, so I'm sorry, I cannot hear him.
Sorry, I didn't notice. I don't think he can hear us.
Sorry, Mr. Kruger, you stood up. Did you want to say something?
Sorry, my lord, at the time, Mr. Murray's microphone was on mute and I could not hear him in response to the answer by Mr. Justice Damaset. If you could just repeat that response to that question, if you don't mind.
Thank you.
His Lordship, Mr. Justice Damasep wanted to know whether it's then irrelevant in the light of our argument that VXK had been liquidated, and the response.
No. Mine was whether it is immaterial that Rockview itself is insolvent.
Yes, sorry, I beg my Lord's pardon. And my response was that in the light of the limited deed of suretyship, the answer is that it is irrelevant. Can I just see whether our learned friend in Pretoria can still hear me, my Lord?
Did you hear that, Mr. Kruger? Sorry.
Did
you get that response, Mr. Kruger?
I'm sorry. I thank you, my lord. I heard that answer.
Thank you.
Thank you.
Then just go to the locus standi issue. We know that authority generally must be interpreted restrictively within the four corners of authority which is relied upon. And in the court a quo, His Lordship, to some extent, compared the receiver there with the liquidator here. But there's no evidence of the kind of powers that are enjoyed by a receiver in terms of the American jurisdiction. One does, with respect, have to look at the terms of the order in which the appointment was made. And that you will find, my lords, at page 15 in volume 1, that order appointed as receiver the firm Finley, Comer and Company. About that, there's no doubt. The order was subsequently renewed. The time period was extended. There's no concern about that. But when you look at the order itself on 1.5, Lords will see the court makes that it was an emergency motion and then filed by the plaintiff branch, banking and trust company against the defendants. And then they're all described. There's GL Marble and Co., GL Marble Atlanta. You'll see next to about marginal line 24, Lords, Nottingham Inc. And in brackets, Nottingham. So there's a clear distinction. There's all these G&L Marble branches, and Nottingham is not a GL Marble. I've read it again because I wondered whether I hadn't missed this GL Marble behind Nottingham's name, but Nottingham Inc. stands on its own. Then if you go over the page, you will see they are at the top referred to collectively as the borrowers or the defendants. And then you'll see there is reference in the fourth line to security agreements. And those security agreements are summarized about at line 30 or 29 as personal property collateral. And Lords, I've read it again. I've asked my learned friend, Mr. Abbas, to read it as well, just in case we missed it somewhere, but I don't see a reference there to Nottingham. Then you go on, there is reference in the following paragraphs going over to, again, specific security deeds. There is reference again to GL Marble. And then you get next to line 10 on page 17 to what is referred to as the personal property collateral, and real property collateral shall be referred to herein as the collateral. So what we have now is a clear reference to collateral without on the face of it any indication of Nottingham's assets or liabilities. That's the point we're making. And you see that at the bottom of the page, Lords, Finley, Comer and Company is now appointed as the receiver. And then on page 18, the fourth line from the top, a principal of the receiver, Peter Comer, will have primary responsibility for the administration of the collateral in accordance with this order. And Lords, unless, because I've read it more than once, I've missed it, there is no collateral associated with Nottingham. And if you go to page 19, the second line authorized the receivers to engage, in the second line, engage counsel to bring on behalf of the borrowers such lawsuits as may be necessary to preserve or recover the collateral. Now, Lords, if our clients had guaranteed GL Marble, then clearly the authority would have been there, and I might have had difficulty to persuade Lords that lawsuits, because that was a sort of fallback position before the court a quo, would not include liquidation proceedings. It possibly would not have survived if that was the only point. And now, in fact, our learned friend during the hearing a quo pointed out that lawsuits surely must include this kind of application. Don't have to go to debate. Our point is that if you look at the authority, it must be looked at within the court order and the four corners of the court order. You can't read into it anything that is not there. Authority being of the nature that it has to be restrictively interpreted. There's no room even to say that it must be implicit because of the very express provisions contained in the order. The order says you, i.e. the receivers, could take such steps as you might want to in relation to the collateral, and that includes steps to preserve or recover the collateral by such lawsuits. Since collateral doesn't get to be defined in relation to Nottingham, our submission is that locus standi is also therefore an issue of devastating consequences to the respondent. And really, therefore, these three issues are in our submission determinable. If there is no locus standi, application should have been dismissed. If the actions were undertaken in circumstances that could, in a trial, be found to have frustrated the rights of the surety, the application should not have been granted. If the suretyship might, once construed in context and with the relevant background circumstances, the evidence and all of that to which there was reference on the papers, have been limited, then likewise, the application should not have been granted. It means, with respect, that we don't even have to worry about section 350. The only point we want to make there is that it might have been an error because previously Rockview was a CC. It converted to a PTY Limited after the contracts had been signed. And so one can understand why the respondent gave a section 69 notice. It's understandable. But it also does raise this question, and that is that it's not a mistake. In other words, if they gave a section 350 notice and in the heading, possibly incorrectly had referred to it as a section 69 notice, then I guess one could get around that on the basis that that form shouldn't take preference above substance, as little as I could have taken the point against my learned friend if he's in his heads of argument by mistake he had headed appellant's heads of argument. It was clearly intended, would have been intended to be the respondent's heads of argument. But the intention here was to give a section 69 notice. So it's not a matter of form. Lords will see that at page 118 in volume 1.
Should we still consider the section 350 issue?
I guess not, Lords. But I do.
Because you are going on to elaborate, that's why I'm asking.
Oh, all I would want to point out, Lord, is that if you look at that notice, you'll see that it was actually one intended to be a section 69 notice. So you can't say, I have given a section 150 notice if your intention was to give in a section 69 notice and try and justify it on the basis that they are similar or provide for similar consequences. But, Lords, I don't want to belabor the hearing. In our submission is more than enough to have, if we are right on any of the three main points, it really, with respect, would be determinable of the appeal, and in favor of the appellant, we've given an indication of the kind of order we would for that the appeal be upheld and the liquidation order be set aside, with the costs including that of 2 instructed counsel. It is, with respect, inevitable if one were to approach it on the basis that I've invited the court at the beginning to approach it. Let's worry about what factual evidence there may or may not be, and whether the surety might have been frustrated or not. It's not the right forum for that now to be ventilated. It's a matter where you simply ask yourself, well, could there be a bona fide defense here? If the answer is yes, with respect, Lords, it's the end of the matter. Unless there is anything else, those are our submissions. Court pleases.
We'll take a short health break. It's just 10 minutes. We should be back at 11:10.
The court pleases.
And the IT people, can we just leave it on? You don't need to disconnect anything. That's what I want to suggest. So that we just come and continue. Thank you. 10 minutes, 11:10. Yes,
And your colleague.
so, yes, yes.
Lord, I think I was muted, so just to repeat, my learned friend's benefit, I'd forgotten to give you a reference and understood your question wrong earlier. My learned friend, Mr. Abbas, told me that the question was, does it make a difference, not that VXK is insolvent, but that Rockview is insolvent? The answer is the same with respect. It doesn't, because you still have to show a claim even before you get to worrying about insolvency. So you have to actually pass through both doors to liquidate a company. You have to have a claim of a certain kind, and then you have to show inability to pay debts or insolvency. And so on our argument, it is not even necessary to go to questions of the liquidity of Rock. There, of course, on the paper is clear indication it has assets to the value of about 56 million with a borrow of about 36 million. And of course, one can't come along and say, yes, but if our disputed claim, once it goes to trial, might be decided in our favor, then you are insolvent. That would be putting the cart before the horses. And then the reference that I admit to give, Lords, is at 78 in volume 1. Sorry, it's my apologies. I omitted to give you the reference at page 78 of volume 1 of our authorities. There's a reference to the Supreme Court of Appeal judgment of Absa Bank and Davidson. And the point made by that and other authorities is that it's not enough for a surety just to say, but you haven't treated me all that well, or you've caused me some vague prejudice. The rest is, it's on at page 78, line 3, or 4 rather. Prejudice caused to the surety can only release the surety, whether totally or partly, if the prejudice is the result of a breach by the creditor of some or other legal duty or obligation. The primary source of a creditor's rights, duties, and obligations are the principal agreement and the deed of suretyship, which is squarely what, with respect, we are talking about in the present case. It's not some vague general complaint, but rather a very specific one in the context of the breach. And then, Lords, we did make a mistake in our heads, for what it is worth, when we referred to Plascon Evans in the first footnote. It's actually an extract from Plascon Evans in the judgment of Coisa versus the Minister of Home Affairs. We apologize for that. As the court pleases.
Yeah, Mr. Kruger, your turn now.
Thank you, my
And
lord.
you don't have to stand, Mr. Kruger. You may sit down if you prefer.
I don't mind. It perhaps is easier if I sit down, if you don't mind, and you will excuse me to do that. My lords, it seems to me that our learned friend for the appellant argues this case without properly looking at the entire construction of the deed of suretyship. Can we, with your leave, go through it? And I point out certain issues that he has not raised. Your lordships will see that on page 113 in volume 1, the deed of suretyship has an introductory part, and then Rockview agree and declare that we are fully acquainted with all the terms and the conditions of the agreement. That's the agreement that has been concluded between other parties. And no act of indulgence, relaxation, or grace granted by Nottingham Incorporated to VXK shall prejudice or affect Nottingham's rights in terms hereof. And if any action by result in an innovation or of any debt or liability between Nottingham Incorporated and VXK and a new transaction concluded in place thereof, then we undertake and agree to be similarly bound as surety and co-principal debtor in favour of Nottingham for such novated debt or liability or such newly concluded transaction. Now, we know that there is a court order both in South Africa and in Namibia against the appellant. The intention, clearly, of paragraph 2 or clause 2 of this suretyship is to say that if there is a novated order, the liability arises from that. If we turn the page, my lords, and we look at paragraph 7, or clause 7 of that contract on page 114, this suretyship shall remain in force as a continuing covering security until such time as all the obligations of VXK to Nottingham Incorporated in terms of the said agreement have been duly and properly fulfilled. In other words, until everything has been paid that is owed by VXK, this deed of suretyship remains in place. Turn to paragraph clause 8. This suretyship shall be in addition to and without prejudice to any other suretyship or securities now held or hereafter held by Nottingham Incorporated from or on behalf of VXK, which means that it is a continuing covering mortgage bond, and there is no limitation. Now we get to an interesting part. The amount of my indebtedness hereunder and that of VXK to Nottingham Incorporated at any time shall be determined and proved by a certificate signed by Nottingham Incorporated or by one of the directors, and whose authority need not be proved, or a certificate in terms of sub-clause 2 hereof shall be binding on us, shall be prima facie proof of the amount of my indebtedness hereafter, and shall be valid as a liquid document against us in any competent court for the purpose of obtaining provisional sentence or judgment against as hereunder. We say, my lords, that if one looks at the court order that was granted against VXK, then that can be read into this clause and proves that there is indebtedness. My learned friend relies on the Badenhorst principle to say there is a defense on reasonable grounds to the claim. What he does not do is address your lordships on the order granted by the liquidator, which was made in order of court. Not the liquidator, my apologies, the arbitrator, and we find that order, Annex MS5 on page 80, where it is said that the respondent is ordered to make payment to the claimant of the sum of $437,000 plus interest. Alternative, the respondent is ordered to make payment to the claimant of the sum of $2.43 million. It is without doubt so, and this appears from the answering affidavit, that the deponent on behalf of the appellant raised these issues during the arbitration. The arbitrator said it is impossible at this point in time, and this is not, his full award is not attached to these papers, but it was attached to the withdrawn application, the withdrawn appeal, the VXK appeal. Arbitrator said it is at this stage impossible to, against delivery of the granite, make an order. So he said it is far easier and in public policy to simply order for payment of the money. And that's where that further payment comes from. If we carry on, my lords, and we look at clause 10 Should Nottingham cede its claim against VXK to any third party, then the suretyship shall be deemed to have been given by me to such cessionary, who shall be entitled to exercise all rights in terms of the deed of suretyship, as if such cessionary were Nottingham. In other words, there is no prohibition, as the appellant tries to argue. This is the widest possible terms and the widest possible implication of a deed of suretyship. Clause 11. Should we at any time in defending any action based on the suretyship allege that there is no reason or cause for VXK's obligations to Nottingham Incorporated, or that errors have been made in the calculation of the amount, then the onus of proving such a defence will rest on us. Can I repeat that? If there is no reason or cause for VXK's obligations to Nottingham Incorporated, that is the crux of the matter. The VXK obligation. Now, if one reads this in context, one sees that VXK's obligation remains extant, well, until its liquidation, and therefore the appellant has to assume it. He is liable to pay, if one reads clause 11. Might I confirm, my lords, we haven't relied on this particular authority, but it is the Bulsara case to which my learned friend has referred. It's Bulsara versus Jordan and Company, 1996, volume 1, SA 805 in the appellate division in South Africa, where at page 809 under the letter H, the following was said. And I undertake that we will immediately after the hearing make a copy of this judgment available to the court. We will send it on to our attorneys and make it available to the court. But this is what was said in that case under the letter H on page 809. It is clear from the wording of the deed of suretyship as a whole that the intention of the parties was not to limit the liabilities in respect of the goods sold and delivered by the creditor to the principal debtor, since the wording was very widely stated to include any other causes of debt arising of such transactions, that is, transactions of sale and delivery of goods, which would include judgment debts in respect of such sales. The deed of suretyship read as a whole supports the interpretation that parties intended to include a judgment debt against the principal debtor for goods sold and delivered by the latter, to the latter by the creditor as the subject of the suretyship. In other words, the deed of suretyship evinces an intention of the parties to cover both the original cause of debt as well as a judgment debt. And we submit, my lords, if one has regard to clause 11, that is exactly what follows here. And I will support that with reference just now to clause 15 and 16. In clause 12, the surety renounces the benefits of excussion, non causa debiti, errore calculi, etc., etc. But if we then jump to clause 15, my lords, and this is where it gets very interesting. If the estate of VXK is provisionally or finally sequestrated, or VXK is placed under provisional or final winding up, our liability hereunder shall not be affected in any way. In particular, the suretyship shall continue to guarantee, subject to all the provisions set out in this document, the payment of any indebtedness of whatsoever nature which may become due by the directors or the provisional liquidator and or liquidator, as the case may be, in connection with the agreement, whether such indebtedness is in respect of loan repayments or damages, or arises in any way of any statutory or other intervention or of one of the above-mentioned persons. So, well, although the introductory paragraph as relied upon by the appellant speaks to the opposite, This particular clause says once VXK is liquidated, wound up, then, my Lord, the floodgates have opened. And which means that the entire argument based on the provisions of section clause 4.3 of the agreement flies out of the window. If we go further to clause 18, this supports what I have said in respect of the liability as a whole of the appellant. If any payment which has the effect of reducing or discharging our liabilities hereunder is set aside under the insolvencies laws or by order of court for any reason whatsoever, or if such payment is refunded to VXK or VXK directors by agreement, or should any security be set aside by the court or to be released by the agreement, we shall be liable to Nottingham in the amount of VXK's indebtedness to Nottingham Incorporated, arising from or revived by the setting aside and or refund of such payment and or the setting aside and release of such security, notwithstanding that the same may take place after the determination of our liability hereunder in other respects, and all reference herein in the obligations of VXK shall include the indebtedness arising from or revived by the setting aside and or refund of such payment or setting aside or release of such security. Nottingham Incorporated shall accordingly be entitled to retain the suretyship notwithstanding any termination of our liability hereunder in other respects, and it is agreed that this suretyship is and shall at all times remain Nottingham's property. So, my lords, with respect, when one reads this document as a whole, the argument that is raised by the appellant does not make sense and cannot be sustained. I draw your attention further to the provisions of clause 17. This suretyship shall continue to bind us irrespective of any reconstruction or amalgamation that may be effected by Nottingham Incorporated with any other company, person or entity, or any change in Nottingham's name, or any complete or partial transfer of Nottingham's business, and shall survive additionally to the benefit of any new entity so created and for the time being continuing Nottingham's business, or any part thereof as successor or assignee to Nottingham Incorporated, whether or not such new entity shall have a different name, objectives, character, or constitution from Nottingham. It is the express intent that this suretyship shall continue to be valid for all purposes and in all respects in favour of any such new entity or other of Nottingham's successors or assigns, as well as Nottingham Incorporated, and may be enforced in the same way in all intents and purposes as if such new entity or other Nottingham successors or assigns had been specifically named and referred to in the suretyship instead of Nottingham. So, my lords, to make it simple, this is not a restrained deed of suretyship. It is as wide as possible. In the intention, clearly, as I've pointed out from clause 11, is to cover all bases. I might confirm that, as clause 18 says, this suretyship constitutes the entire agreement between ourselves and Nottingham Incorporated, and has no variation, and no variation thereof shall be of any force and effect unless it is in writing and signed by both Nottingham Incorporated and ourselves. So, my lords, bearing in mind, as we see from clause 21, that this suretyship has to be interpreted in terms of the laws of South Africa, it seems to us and we make this submission to the court, that the argument put forward by the appellant that the suretyship is limited in its nature is wrong and cannot be enforced is also wrong. But what is even more clear, my lords, is that by virtue of this deed of suretyship, when a letter of demand was written by the respondent's attorneys to the appellant, it made an admission, and my learned friend does not address that. If you turn to page 8 and in paragraph 17 of the founding affidavit, you see an amazing sentence. On 29 July 2015, sorry, it starts off earlier. Rothman, the South African attorney, met with the director and legal representative of VXK on 7 July 2015 in order to procure payment of the amount owed to the applicant. VXK indicated that it would make an offer of payment to the applicant. On 29 July, the attorneys of the respondent, and in brackets VXK, wrote to Rothman to make an offer of settlement to the applicant. Now, this is admitted in the opposing affidavit, and you will find that, my lords, on page 196, in paragraph 7 tie. I admit the allegations in paragraph 17 and 18. Now, we have referred in our heads of arguments, my lords, to the case of Hammerly that was handed down in South Africa. That case says, and this was our argument in the court of quo, and the learned judge of quo agreed with us. That is an admission of liability. The moment a debtor or a surety says, yes, I accept, and he makes an offer of settlement, my lord, we say that is an admission of liability. That takes away the entire argument on behalf of the appellant that this matter should be referred to trial. At the end of the day, that admission of liability means that the appellant accepts that it is liable. If it was not liable, it would not have made that admission, not so. So we say, my lord, on the papers as they stand, and despite the argument suggested by our learned friends, that prescription does not even come into play because of that admission that you find on page 196. Because an admission of liability interrupts prescription and it commences to run de novo. So, on both grounds, my lord, whether there is a possible defense or on the issue of prescription, your lordships, with respect, the court cannot hold in favor of the appellant. What happened, or should have happened, if the respondent had, if the appellant had denied liability, it should have not made an offer of settlement, it should have declined to admit its liability.
The admission obviates any admission, any defences.
And, my Lord, I make this statement or this submission to the court. That admission, like an acknowledgement of debt, obviates any prior or other defences that might have existed. So, I suggest to the court.
Frank is looking.
Sorry, can you hear me now?
Thank you, my Lord.
Yes, I just want to ask you that, what is the admission of liability? Is it MS9?
Yes, it was the letter that was blanked out.
Is it MS9 at page 89?
Indeed, my Lord.
But, I mean, is there an admission of liability in that letter?
Well,
Can you just show me?
you must read that in conjunction with the founding affidavit and the acknowledgement in the answering affidavit.
Yes, but I mean, they just admit that you guys, that the attorney spoke with VXK.
No, it is said in paragraph 17 that an offer was made. On 29, wrote to Rothman to make an offer of settlement. That's on page 8.
Yes.
And that is admitted.
But I thought that was the letter.
This is, so MS9 is the letter. I can make available to the court the letter, the entire letter. But it is not.
No, I don't want, but can you tell me where in the letter is the admission you're referring to? In MS9. MS9.
In the letter itself, there is no such admission, my Lord.
Okay. Okay, sorry, you've answered my question. You can move on. Thank you.
Thank you, my Lord. So we say, notwithstanding any argument, and I'm repeating myself actually, there is a court order. That court order was not defended either in South Africa or in Namibia by the High Court that confirmed the decision of the arbitrator, which ordered the appellant to make certain payments. And we say, by virtue of the fact that if it had a case, it should have, because Mr. Weekly, who was the deponent, was involved, the controlling mind of both the appellant and VXK was involved in the arbitration. He admits that. He said in the opposing papers, he says these issues were raised. And if he was dissatisfied, or VXK or the appellant were dissatisfied, was dissatisfied.
Just one moment, Mr. Gruber. My colleague wants to ask.
You are muted, my lords. Whoever wants to ask the question is muted on his computer.
It's just a smart.
I'm now unmuted. Yes. In paragraph 17, you rely essentially for the admission of that paragraph as an admission of liability.
Yes.
But it's not clear to me that the respondent in this, beg your pardon, the appellant in this appeal necessarily is making admission, because the sentence is VXK indicated it would want to make an offer of payment to the applicant. Now, I'm just asking you, it would seem that VXK is admitting liability, and it doesn't seem to be unequivocally an admission of liability, what is even stated by on behalf of the respondent in the founding affidavit amounts to an unequivocal admission by Rockview of its liability to the to Nottingham. It's more. It would more appear to me a VXK admission of liability. I just wanted to ask you that.
My Lord, Your Lordship, can I answer it in this way? If the liability was only made by VXK and not by the appellant, surely it would have been responded to in the answering affidavit by saying that only VXK had made an offer of settlement. Because as it stands, it's paragraph 17 says that the respondent, the attorneys on behalf of the respondent made an offer of settlement. The letter was written without prejudice. And if it had not been an offer of settlement, why would it have been written without prejudice? So if you read it in context and you look at the direct admission by the appellant, that surely, my Lord, means that it must be accepted that the offer was made by the, while we speak here of the respondent, by the appellant before you.
That you can attempt to settle the disputes.
What paragraph is that?
70.2, page 196. 196.
Paragraph?
72, so it's a genuine.
If your lordships were to look at paragraph page 196, paragraph 70.2,
He says, I over that.
and you see what is said by the deponent. He says, I aver that it is not open to the applicant to rely upon the correspondence without prejudice in a genuine attempt to settle the dispute between the parties. And that since the financial statements and management accounts were submitted in the course of the settlement proposals, that these documents are equally inadmissible in these proceedings on the basis that they were privileged and stand to be struck out with the appropriate relief as to cost. I nevertheless admit the allegations in paragraph 9, sorry. So, my lords, the defense is not that we have not made an offer. The defense is you cannot rely on the letter of settlement or the proposal.
There's no doubt that that admission has been made.
You're still muted, my lord. You're still muted.
I don't seem to have control of that. But thank you. You can move on.
Thank you, my lord. I do apologize if I point out that I can't hear you, then I am in the same position as your lordship. My children knows these things and they play and so my lord, with respect, I've covered the issue of the merits. There is no defense there. That means that in any case that the issue of prescription does not come into play for two reasons. One, because of the admission, and two, because of the date of the court order. That, in any case, my lords, we say that if the respondent were in a position to pay, it would have paid and should have paid. It failed to pay. And is there a clearer indication that it is not capable of paying than its failure to pay? The fact that it had made a proposal indicates to us that it was, and we make the submission, that it was not in a position to pay the full $2.5 million of its liability. My Lords, the two other issues that were raised by my learned friend in argument this morning turns on the authority of the page 15
No, the order of voting.
of the applicant. We say, my Lords, and that is Annex MS1, that he says because there is very limited reference to Nottingham, Nottingham cannot bring this application before your Lordships. But there are two answers to that, my Lord. The first is that Nottingham took an order in the Namibian High Court. That order has not been set aside. That order is enforceable until it is set aside for whatever reason. So the party that has an enforceable court order is Nottingham itself. So the argument raised by my learned friend that there is no reference or not enough reference in Annex MS1 is refuted by the fact that it's a court order. But in any case, even if one were to look at Annex MS1 on page 15, one sees Nottingham is noted on page 1, and then the following happens. If you turn to page 16, as my learned friend pointed out, right at the top, it says, this matter has become before the court on an emergency motion. On page 16, concerning certain collateral as further described in the emergency motion and a verified complaint filed in connection with this above styled civil action. And if your Lordships then carry on, your Lordship sees right at the end on page 25, your Lordship sees that this emergency order was signed by Nottingham Incorporated and indicating that they were not opposing the application. So we say, on a wide interpretation of this order, it is clear that Nottingham was a party thereto, Nottingham was part of the collateral, and under these circumstances, nothing turns on the argument by our learned friend that Nottingham did not have jurisdiction. But as we say, there's a better point, and that better point is there's a court order made in Windhoek that refutes this entire argument and was never.
The resolution.
On page 264. 284. My learned junior, my lords, says, I must also point out to your Lordships the resolution by Finley Colmer on page 284, that is Annex MS 15 to the replying affidavit.
Frank is asking.
Which,
Sorry, that resolution authorizes Smith. It's nothing to do with the authorization for Colmer.
your Lordship is correct. I'm not taking that point any further. I'll leave it there. So, my lords, the other argument raised by my learned friend was that the letter was written as a letter of demand and should have been written in terms of section 350, but it was written in terms of section 69 of the Act. The principle remains the same, my lord. Whether it is against a company or a closed corporation, let me just get to that letter of demand. Your Lordships find that on page 116, Annex MS 12, Rockview is a closed corporation, on the papers at least. And the letter of demand is written in terms of section 69 of the Closed Corporation Act to a closed corporation.
They converted.
Hmm?
They converted.
So, although there is some confusion as to whether it was written in terms of section 350, as it stands, my lords, it is a letter written in terms of section 69 of the Close Corporation. My lords, we submit to your lordships that there is no merit in this appeal. The appeal stands to be dismissed with costs, including the cost of 2 instructed and 1 instructing counsel. I don't know if your lordships have any further questions to us or anything is otherwise unclear.
Yes, my brother Smart will ask.
Thank you. Thank you, my lord. Unmuted, my lord. There we are.
Yes. The issue of this locus standi point, what concerns me is that the collateral doesn't seem to include Nottingham. It seems to be defined with reference to collateral of other companies within that group, the personal property collateral. And this obviously would not fall within the realm of real collateral, so real property collateral. I just want to ask you again, going back to this court order, which we have to interpret, how this would then authorize the receiver to institute proceedings against Rockview for the collateral involving Nottingham. I just want to hear you, because Mr. Murray made the point that Nottingham doesn't feature with reference to the definition of collateral in this instrument, this court order.
My lord, Mr. Murray is in the introduction, he is correct, and I cannot take it very much further than that. But again, the better point that I have submitted to your lordship is this: the arbitrator would not have made an order against VXK had it not been satisfied. And I will look at this issue again, and if need be, I will file supplementary heads on the papers as they stand, if your lordships were to allow me. I didn't understand that this point was going to be taken, but I say to your lordships, there is a court order, an enforceable court order, which grants relief in favor of the Nottingham Incorporated against VXK. Once that is the case, Nottingham is entitled to proceed against the appellant. Even on the papers as they stand, if your lordships were to find that Annexure MS1 is not sufficient, does not take away from the enforceable court order. And that has never been disputed.
Justice Frank.
Yes, but someone must be authorized to act on behalf of the company if they want to enforce the court order.
My lord.
And where's that authority? Because this is not the director and this is not the shareholders.
But the receiver, with respect, has a court order. And that court order is not in dispute.
Yeah, but then we run into the Miller problem. Because if he wants to act as a receiver, not as the company, then he must get recognition in this court.
My lord, but that point was never raised previously. Not in the High Court, at least. When
It was.
Not in the High Court.
maybe not in that context, but the Miller case was definitely referred to because the judge distinguished this matter because the company is the claimant, and according to him, the order obviously gave the receiver the right to act for the company.
Yeah. My Lord, if your Lordships will allow me, I've not necessarily prepared on this particular point. If you will allow me to file further heads by no later than Monday on this particular point, if this is a contentious issue, then I will ask for that.
I will just ask you, so is that on the point that because there's an existing court order that gives the person locus or authority?
Indeed, my Lord.
Yes, I'm not unmindful of the offer made, and I'll deal with it at the end, Mr. Kruger. Thank you very much.
Thank you. So, my Lords, I will ask you to dismiss the appeal with costs as requested. Thank you, my Lord.
Thank you very much, Mr. Kruger. And Mr. Murray, in reply, please.
Lord, I think the starting point would be when we deal with the approach that was adopted by the arbitrator. That doesn't have any effect upon this court. The arbitrator might have been satisfied that there is no defense in clause 4.3, whatever it was. He might have been satisfied about the fact that there was locus standi. But what Cassie Bardorf said is not going to be of any effect in different proceedings where different parties are before court. The argument about, therefore, the fact that there was a judgment granted pursuant to the arbitrator's finding is really of no consequence when it comes to the issues that are before court. We come back to the provisions of the deed of suretyship. And what our learned friends are saying is used phrase like, it covered all bases. And then he also suggested that you can just throw clause 4.3 out of the window. And in support of those submissions, referred to other provisions on the second page of the deed of suretyship that in his submission indicated that what we had here was, as he put it, a wide or cover all bases kind of suretyship. But that argument, with respect, ignores entirely two important entries in the deed of suretyship. There are two times when the word only is used. The first one is just underneath the next to line 20, where that paragraph follows after year and after VXK, because it started off by saying that Nottingham signed itself as surety and co-principals for the due and proper fulfillment of all obligations of and for the payment of sums. And then it follows in terms of or in connection with or arising out of the provisions of only clause 4.3. And in that same paragraph again, in the last line, it is recorded that this is limited by virtue of clause 4.3 of the agreement only. Now, if one were to suggest that we are dealing here with a wide cover all bases kind of suretyship, then we must ignore that. And you can't do that. Then it doesn't sit with the remaining clauses, because that is very express and very specific. And so there may be a clause that says that there would be a certificate indicating the amount that is owed. But you come back to the question, why then do we have these two restricted references? Because they can't be read in the context of anything else but an obligation to make payment by kind. And so it is not with respect a cover all bases kind of suretyship. In the Bulsara case on which our learned friend relied specifically, we've made a copy of that judgment, and the Lords will find it in volume 2 of our authorities. And specifically at page 141, what the Supreme Court of Appeal there said in the middle of the page is, The crux of the debate was whether the judgment debt constituted a new and a separate cause of action in respect of which prescription would commence running independently of the cause of action arising from the goods sold and delivered. And His Lordship, Justice Joubert, then went further to say, Counsel were at idem, in my view, correctly, that this question has to be decided exclusively with reference to interpretation of the deed of suretyship. And he then went to the deed of suretyship, and it would appear that the judgment was then heavily influenced by what is reflected there, because there it says that the surety bound himself as surety and co-principal debtor for payment of all amounts due by the principal debtor in respect of goods sold and delivered. But then it went further, or for any other causes of debt arising out of such transactions, i.e., goods sold and delivered may give rise to a judgment, and it therefore would arise out of goods sold and delivered, and therefore it might therefore not have prescribed. Here we have very clearly a very specific restriction, or in fact on more than one occasion, two specific restrictions. And that sits well with the reference to which I've referred the court earlier about the novation. It's a specific kind of novation. I guess a judgment might, in a sense, novate to an extent an earlier debt, but I'm not sure if that is so, because novation is a really typical form of contract where one contract is replaced with another. But even if there was doubt at a general level, this document itself speaks of novation as a transaction concluded. It can only be in the context of another agreement, and we are not concerned with that.
Mr. Murray, sorry, I just want to ask you something.
Yes, ma'am.
I've unmuted it. What does the liquidator of VXK do with this contract?
The liquidator must obviously walk into the shoes that was occupied previously by Nottingham.
No.
I mean, you mean
VXK.
VXK.
He's sitting there, the people, as they've got a claim for 2.5 million. How does he?
The liquidator would be entitled, having now walked into the shoes of VXK before the judgment. The liquidator might have raised the defenses of the fact that there was no compliance.
No, after the judgment.
Now that there is a judgment, the liquidator has no means by which he can go behind that judgment. The payment must be made on the basis of, first, the arbitration award where the issue was alive and dealt with, and that award was never appealed. Then there was a court order made, and that was then also made in court here. But we submit that the position is entirely different when we're talking about Rockview.
But isn't that where clause 15 kicks in?
My Lord, if you look at the provisions of clause 15, you've got to read them in harmony with those earlier two references. And they, with respect, it says, if it's wound up, then liability shall not be affected in any way. It must mean that the liability is not cancelled as a result of the liquidation, but it doesn't convert that liability into anything else than an undertaking to have complied with 4.3, where it is twice referred to. And that is why we keep saying, Lords, that Rockview is entitled to say, you have not ordered, that defense has been found to have been rejected as it were from VXK. But we can still raise that as a defense as long as we are entitled to say that our liability is limited by 4.3. And of course, then it also brings into play the question of the fact that the liability or the ability to perform was frustrated. before the judgment? I submit yes. He would say to them, and there's clear evidence that you can, for example, also avoid liability. It began way back with Foot, and we've given you the references in the supplementary bundles to Wessels, also saying that if you've tendered, not necessarily in consignatio in a tender in court, but even out of court, if you've made a tender and the other side doesn't accept the tender, you're discharged of that liability, or at least suspended. And we come back to the fact that on the facts before you, there's no gainsaying evidence, Lords. That is exactly what VXK did. The arbitrator, I don't know how he got there. I read the judgment. He converted a claim that was ad praestandum into a monetary claim. But the fact of the matter is you can't get away from the fact that payment had to be made in kind. And the creditor says, no, I'm sorry, we're not going to accept granite because we're winding up our affairs. And both VXK and now Rockview is entitled to say, but you can't do that. We had all the granite stockpiled for a whole 12 months to deliver to you. I, as the surety, I undertook that obligation knowing that there would be the stockpile and that you would carry on ordering. Now, 3 months later, you suddenly hit the ropes. You've got a liquidator breathing down your neck. And now you want us to make a payment to you at the very best for Rockview. That is a clear example of a breach of contract in circumstances which would release Rockview in terms of its obligation, because it's a breach of contract towards the principal debtor. And so whatever might have happened subsequently in the process that flowed through the arbitrator with respect is of no consequence. Our learned friend then made reference to the fact that liability was admitted. Perhaps I should just give you a context to the purpose behind that. In the heads of argument of the respondent, much reference was made to this judgment in Hammerley Group. The purpose behind that was because in that judgment, the court accepted that if in the course of settlement negotiations, you admit that you're insolvent, you can't come and cry later and say that they can't rely on that act of insolvency, because that would be against public policy to allow you to do that. And one sees it from the quotation that's in our Learned Friends heads at page 8 of the heads of argument. The quotation reads, where a party therefore, it's in the middle of the quotation under paragraph 24, Lords, page 8 of their heads, where a party therefore concedes insolvency, as the respondent did in this case, public policy dictates that such admissions of insolvency should not be precluded from sequestration or winding up proceedings, even if made on a privileged occasion. So what we're talking about is a classic case where suddenly you want to get rid of a creditor and you make an offer and effectively you are saying, I can't pay you anything more, this is what I'll pay you. We all know then you are effectively giving rise to a recognized ground. That's the context. If we go back to what is in the affidavits, Lord Justice Smuts is quite correct with respect. There is no admission of liability, not there or in the annexure. In fact, if you look at MS9, Lords will find that there is absolutely no acknowledgement of debt. Our learned friend perhaps mistakenly used the phrase an admission of liability. And at another stage, I think he referred to an acknowledgement of debt. But start perhaps with MS9, and my Lords will see at page 89, there is a reference to the assets and liabilities, and no admission of any kind is made. So there is no assistance to be derived from that document. When you go to paragraph 17 to see whether there is anything more there, Lords will see what is stated is that VXK indicated that it would make an offer of payment to the applicant. And then it goes on to say on the 29th of July 15, the attorneys of the respondent and VXK wrote to Mr. Rothman to make an offer of settlement to the applicant. That's not an admission of liability. For all we know, it might have said, we'll pay you 100 rand, go away. It's going to cost me more than that to see counsel. You can't rely on that to suggest that that amounts now to an admission of liability to interrupt prescription. And the provisions surrounding the Prescription Act is quite clear. It is an acknowledgement of liability. It says in section 14, the running of prescription shall be interrupted by an express or a tacit acknowledgement of liability by the debtor. And there are a lot of cases where somebody comes along, the debtor might be his son, and he says, well, I'll make you a payment to go away. That's not an admission of liability. It's an offer of settlement that is aimed at trying to get rid of something. And then, of course, what happens is your prescription is interrupted, not revived. And that is important because my learned junior pointed out, Lords, that the demand was made in September 2011. The admission of liability on the respondent's version was made on the 29th of July 2015. It's a good 4 years later. So it's in any event with respect an entirely immaterial point. We would submit, Lords, that the application should never have been granted in the first place.
Mr. Murray, what is your attitude in respect of the request made by your colleague?
Lords, I'm not pedantic about matters like this, Lord. I don't mind if he wants to file anything in supplementation, if the Lords were to allow that.
So it's fine with you?
I don't object to that, as long as we don't delay the matter long, Lord. And of course, if he would serve it on us, let's say by Monday, and perhaps we can respond if we need to by Tuesday, then justice could be done. In fairness to him, we did send him references to the new cases that we found subsequently during the course of the morning and yesterday, and he raised no objection. I can only reciprocate.
It's on the authority point of the receiver. Mr. Kruger, I've consulted with my colleagues. We are willing to grant you an opportunity to file a supplementary heads, very, very brief ones on that issue by close of business on Monday, and allow Mr. Murray to do so, close of business on Tuesday. Will that be in order?
That is in order, my lords. If your lordships will grant me an indulgence, I will still prepare the heads. But I've looked at the issue. If your lordships, if I can just shortly take you there. Your lordship sees that... Is
that on the very issue on which you want to file supplementary heads?
Absolutely. Perhaps we can dispose of that. If necessary, I will file further heads. Your lordship sees...
Well, you can't have it both ways. Yes, go ahead. Go ahead, please. Go ahead.
If your lordships were agreeable, then it agrees with me that the issue turns on the claim of this bank. The Branch Banking and Trust Company is the bank's name, and it is in respect of the collateral of GNL Marble. Now, your lordships, if you were to carry on and look to the contract itself, and more specifically on page 57, let's just start on 55. The seller means Nottingham Incorporated. It's clause 1.2.28. Your lordships then turn to paragraph 57, clause 2.1.2. Your lordship sees that BB&T, the bankers of the seller, confirm in writing to the purchaser or its representative that against payment of the amount of $2 million by the purchaser to the seller into the bank account designated by BB&T, the security interest and any other interest of whatever nature that they may have in and to the sale, shares and claims shall have been cancelled, that they may waive and abandon any claim whatsoever nature that they may have in and to the sales and shares, and that they approve of this transaction. Then, if your lordship turns to page 59, your lordship sees in clause 4.5 that the nominated bank account of the seller is the following. It is G&L Marble Incorporated. In other words, the benefit of this sale agreement was in favor of G&L Marble. And that brings us back to the point where the receiver was appointed in favor of G&L Marble, which means that Nottingham as the seller was in terms of the contract correctly the claimant in the arbitration proceedings, but the benefit accrued to G&L Marble, and that brings us back to the appointment or the court order for the appointment of the receiver. G&L Marble's benefit that accrued. The benefit was for the benefit of, or the sale was for the benefit of G&L Marble. Under these circumstances, my lords, I submit to your lordships, if you read the entire order in its context, you will see that because G&L Marble's, the collateral or the interest of G&L Marble forms the collateral, that is the answer to Mr. Justice Smith's question. And under those circumstances, I do not propose to draft and submit further heads, my lord. There we are. Sorry, my lord, I couldn't hear you. You were muted.
I learned, friend, I was muted. Shall I repeat for his benefit? Sorry.
Yes, please.
Sorry. What I did was to invite Mr. Mare in case he wanted to say something in reply to what he said, and he has declined the offer.
Thank you, my lord. I can't go there.
Well, what's left for me is on behalf of my colleagues, myself, to thank both of you for your submissions, both written and oral, and particularly wish to thank our technical people for making all this possible, and Mr. Kruger, who sits in a faraway place with your junior, for participating in these proceedings. Thank you very much. Judgment is reserved. Parties will be advised when we are ready with the judgment. We rise now.
Thank you, my lord. Jean, baie dankie. Jean, baie dankie. Ek sal jou ander dag weer sien.